morning, Judge Lekar.
Good morning.
Welcome, and we're ready for your opening remarks.
Good morning to all of you. Thank you for your service on this commission. I think all of you know my professional resume from the application that I submitted. I want to take a little bit of time to introduce myself to you personally as well. I am a native Iowan. I am married to my high school sweetheart. We've been married for the last 28 years. He is an architect and a partner in a firm in downtown Waterloo. We have 3 children, ages 17, 16, and 14. We send our oldest child off to Iowa State this fall, and we will have 2 remaining in high school. I've been a lawyer since 1993. I practiced for 12 years in Northeast Iowa. I was named as a district court judge in 2005, and I became the chief judge of the 1st Judicial District in 2012. Many of you know from looking at my application that my dad was a big influence on me in my childhood. When I was a child and someone would ask my father what he did for a living, his first answer always was, "I am a federal civil servant." And as I grew up and I heard him say this over the years, I realized that he didn't do that simply because it was easier than saying or explaining that he was a weapons and heavy machinery inspector for the Department of Defense. He said it because he was proud to work in service to his country. He was proud to be a federal civil servant. And in the time that I've been a judge, I have found that when people ask me what I do for a living, my first response is, I work for the state of Iowa. And I do that not just because it's easier than explaining to people the work I do as a judge, but like my dad, I am proud to be someone who works in service. In my case, I work in service to my state. I am a state of Iowa civil servant. I am a 1990 graduate of Iowa State University with honors and distinction. My undergraduate field of study was in psychology. However, during the time that I was engaged in my undergraduate studies, I found that more and more I was taking classes surrounding political science and American history, and it dawned on me at some point that I had a real passion for American government. I earned a full ride merit scholarship to the University of Iowa College of Law. I graduated from there with distinction in 1993. After that, I joined a practice in Waterloo, practicing primarily in insurance defense for approximately 3 years. From that point forward, I built my own practice. That practice was in family law, juvenile court, business law, real estate, municipal law, appellate practice, and all or many other areas of general civil practice in a county seat town. From the time that I entered law school, I knew that studying the law was the place where I wanted to be. From the time that I entered the practice of law, I knew that being in a courtroom and writing and arguing about legal concepts was what I wanted to do. During the early years of my career, I was encouraged by a number of judges to apply for the trial court bench, and I did that and was appointed in 2005. And from the time I took the bench, I became very interested in how our judicial branch as a whole functions and is administrated. And I took my opportunity to become more involved in the administration of the judicial branch and the 1st Judicial District by applying for and being appointed as Chief Judge of the 1st Judicial District in 2012. All of these things have brought me to where I am here today, sitting before you as an applicant for the Supreme Court. As I've gone around and interviewed with many of you in preparation for today, one compelling question that has been asked by many of you can be narrowed down to this. In a field of qualified applicants, how do you distinguish your qualifications? And I'd like to discuss with you 3 critical areas that I believe distinguish my qualifications. First of all, I believe I have an ability to bring the perspective and the interest of both urban and rural Iowans to the Supreme Court. Second, I believe I have a proven record of court leadership. And third, I believe I have a legal experience that is both broad and deep in areas that are important to the Supreme Court. With regard to the first issue, the 1st Judicial District covers 11 counties in northeast Iowa. 2 of those counties are urban, Black Hawk and Dubuque. 9 of those counties are rural. I have covered court days and trials in every one of those counties. I know what it's like to sit in a rural county court day where the attorneys in that county show up at 9 a.m., sit around the table in the conference room with their cup of coffee, and discuss the day's business. They discuss the day's law, the day's cases, the news of the community, and their daily lives. I've presided over large family farm divorces, small business divorces, property disputes between country neighbors and city neighbors. I've presided over high-volume rocket docket court days in criminal law in Black Hawk and Dubuque counties. I've sat in Black Hawk County on a Tuesday morning when we were starting 5 jury trials in that courthouse that day. All of this allows me to have a perspective on the interest of both rural Iowans and urban Iowans. I know the attorneys, the litigants, the law enforcement, the communities, and the way of life in a large corner of the state of Iowa. And I am familiar with the common set of core values of all Iowans, as well as the diverse interests of both urban and rural Iowans. As to the second way that I distinguish myself, I do have a proven record of court leadership. From the time that I've become a judge, I've invested myself in both opportunities for professional growth and personal growth. Since becoming chief judge for the past 6 years, I've had an opportunity to be involved in innovative court projects, which include domestic violence court, family law mediation, mental health jail diversion, and jury management. Each of these opportunities, I have been a leader of a collaborative system, a collaborative project involving community stakeholders, where we work together to make our court system more efficient, more responsive to the citizens of Iowa, and to build confidence in the judicial branch. Also, as Chief Judge, I serve as part of Judicial Council. Judicial Council is made up of the Chief Justice of the Supreme Court, the Chief Judge of the Court of Appeals, and the Chief Judges of the 8 judicial districts of Iowa. As a representative on the Judicial Council, I have an opportunity to lead and represent the interests of the 1st Judicial District. I also have an opportunity to have input and give advice to the Supreme Court on areas of interest, areas of statewide interest in the administration of the judicial branch. One of the most interesting and compelling opportunities that I've had as a chief judge was the opportunity to participate in a county-by-county road trip with Justice Sager in 2012. At that time, I was new to being chief judge. He was relatively new to being a Supreme Court justice. And we took a 2-week period in the summer of 2012, and we went county by county within our district. And we spent a day, or nearly a day, in each of those counties. And we met informally with clerk staff, with law enforcement, with boards of supervisors, with community stakeholders, with other county officials, and with the attorneys in those counties. And we discussed areas of common interest, such as courthouse management, courthouse security, EDMS, collaborative uses of resources, and responses to vulnerable citizens in our communities, such as youth, elderly, and the mentally ill. And from that trip, I learned that many citizens in the state of Iowa are working to address common challenges, that they have a solid commitment, and that they have a diversity of interests in how our judicial branch is administered. The third way that I distinguish myself as a candidate before you here today is in the extent of my experience. As an attorney and as a judge over the past 25 years, I have had opportunities for broad experience in the practice of law. This includes being involved in a wide range of civil matters and also being engaged as a judge, presiding over criminal cases ranging from simple misdemeanors to Class A felonies. However, although my experience is broad, I also believe that my experience is deep in critical areas that come before the Supreme Court on a regular basis. A quick survey of the 94 decisions that were issued by the Supreme Court during the last term shows that 33 of those decisions dealt with criminal law, 11 of those decisions dealt with post-conviction relief, and 4 of those decisions dealt with juvenile law. Of the 33 criminal decisions, at least 4 of those decisions dealt with the important and emerging vein of law concerning juvenile offenders and the sentencing of those juvenile offenders. This means that 1/3 of the cases before the Supreme Court last year were criminal, and when you add in the post-conviction cases and the juvenile cases, a full 1/2 of the cases before the court touched on those areas of the law. I believe that my experience in these areas runs deep. For 10 years in the practice of law, I accepted court-appointed assignments to juvenile court cases, doing child abuse and neglect cases. Once I took the bench, I volunteered for a 2-year assignment to the juvenile court bench, in which I presided over both child abuse and neglect cases as well as delinquency cases. For the other 11 years that I have been a district court judge, I have served as a backup juvenile court judge. I also believe that my experience runs deep with regard to criminal cases. Black Hawk County is a high-volume criminal court county. As a matter of fact, a few years ago, when the data came out about the number of felony jury trials that had been tried across the state, Black Hawk County had tried just 1 less felony jury trial than Polk County in that same year. In Black Hawk County, I've had the opportunity to preside over more than 50 criminal jury trials. I've taken over 1,000 guilty plea colloquies, and I've been involved in countless suppression hearings and other issues of criminal law that frequently come before the Supreme Court. I think that my experience shows to you that I am both broad in my knowledge of the law and deep in my experience of the law in certain critical areas. In conclusion, it is especially important and meaningful for me to be here today to address you with regard to my application for this position that's created by the vacancy and the retirement of Justice Bruce Zager. Justice Zager and I were both attorneys practicing in the Black Hawk County Bar together. We were colleagues on the bench in the 1st Judicial District. And since he's become a justice on the Supreme Court, we've continued our working relationship, both on the county-by-county tour that I previously described to you, and also through participation more recently on the Guardianship and Conservatorship Reform Task Force. I have witnessed Justice Zager's service to the practice of law and to the judicial branch, and that service is something that I would hope to emulate if provided with an opportunity for appointment to the Supreme Court. Thank you for your service on this commission. Thank you for listening today. I'd be happy to take questions.
Thank you, Judge Lekar. We're going to start with, I've lost my notes here. We're going to start with Ms. Pearson this time. Mrs. Pearson.
Thank you. Is this on okay?
Yes.
My question, is with regard to your experience as Chief Judge, which is a compliment to you. And I just wanted you to maybe expand a bit on that as to any specific opportunities or situations that you encountered that you feel have really helped, define or give you an edge to help you to be more prepared, for the position on the Supreme Court. You commented about your tour and so forth, and I believe you commented that you encountered many citizens that face common challenges. And what are some of those things that you'd like to expand upon, and what recommendations would you make to improve them?
Being chief judge gives me a unique opportunity to be the face of the First Judicial District in many circumstances. And I think the Supreme Court sits in a very similar circumstance in that often they are the face of the judicial branch. They are the people that are looked to when a difficult decision needs to be made, when a public statement needs to be made, or when citizens desire to have a response from the judicial branch. And certainly as chief judge, I've then been put in that position to be that representative for the First Judicial District. What I've learned is that as a judge, you preside over a case and you make a decision about that case as a trial court judge. As the Supreme Court, frequently when you make a decision in a case, you have to think about the precedent you're setting, and you have to take the long view on the decisions that you're making. And being chief judge puts a person in a similar position with regard to the setting of policy within the judicial district. It's important when we set policy that we take the long view of the impact that policy would have on not just a particular case, but the entirety of judicial administration within that judicial district, so that we have consistency, so that we are accessible, so that we are responsive to the needs of our citizens, so that we are responsive to issues such as disproportionate minority contact, self-represented litigants, budgetary issues, and other issues that come before our court system. So I think that's what I've learned, that the Supreme Court and others in leadership in the judicial branch need to be prepared to take that long view and need to be prepared to be consistent and organized and practical in their response to those issues.
Thank you.
Thank you.
Ms. Bowden?
Thank you. Judge, you indicated that you've done, when you start out in your practice, defense work, and then you switched over to plaintiff's work, and now you have a role as a judge. Can you explain what you learned from each of those roles and how those would transfer over into your decision-making process as a Supreme Court Justice?
Having had an opportunity to work for 3 years as an attorney in a firm that primarily did insurance defense work, that's where I cut my teeth in the practice of law. And that's where I had examples of attorneys and partners who taught me the value of researching and writing and being prepared to be present in the courtroom and to argue a position. When I built my practice of law and that practice of law became more involved with personal injury work, I did some personal injury work. I had partners who did personal injury plaintiffs work. Representing an individual and taking on and feeling as if you're taking up the cause of their case leads you to build a different skill set, or build onto that skill set of not only being a good litigant or a good attorney, a good advocate in the courtroom. It also puts you in a position of understanding the position of your clients, building empathy, and being able to communicate complex legal issues to your client in a way that they understand, and then take their claim, their argument, their cause to the court and to a jury. And I think it gave me a perspective of the entirety of how the system works, that there are people who bring their causes of action, and there are people who rightly defend those causes of action as well, and that everyone needs to have an opportunity for a voice in the court process.
Thank you.
Thank you.
Mr. Berger? Mr. Diaz? Dr. Taylor? Mr. Bevel?
Thank you. Good morning, Judge Lekar.
Good morning.
I've learned of a change that you were a driving force behind in Black Hawk County related to probation. And have a significant issue of disproportionate minority imprisonment coming from Black Hawk County. Could you explain to the commission what that change was and what drove you to lead it?
Yes. Disproportionate minority contact is an issue in Black Hawk County. It's an issue in our state. It's an issue in our nation. And it's something that we all need to work together collaboratively to address. And from the standpoint of the judicial system, there are various opportunities in the process where we have that opportunity to address that issue. We have the opportunity at initial appearances in the setting of bond. We have that opportunity in the issue of pretrial release. We have that issue during the course of jury trials. We have that opportunity during sentencing, but we also have that issue during probation and probation violation cases. When an individual is sentenced to probation, they have a probation officer. And the system in Black Hawk County had come to a point where frequently a probation officer would have someone on probation and that person would violate probation. Sometimes it was a technical violation. Technical violations are not where someone goes out and gets a new law charge, but where they go out and they miss an appointment, or they, what we call drop a dirty UA, provide a drug test. The situation we were facing is this: the probation officers were allowing those probation violations to stack up to the point that when they brought that to the attention of the court, so many violations had occurred that the court was really left with no option other than to revoke probation and send that person to prison. And what we did is we tried to get ahead of that issue, because there was, as with many of the things that we do, a disproportionate minority impact of those types of decisions, because we were, as a result, taking a large number of African American people who were on probation and waiting to the point that they had so many probation violations that their only option was to go to prison, that there were no other community resources. And what we did is we looked to intervene in that process earlier through court leadership by bringing those cases, we call it a fast track program, by bringing those cases when an individual has only 1 or 2 violations, before those violations have stacked up to the point that they're so bad. And when they've had only 1 or 2 violations, it gives us the opportunity to intervene, to have that contact, to readjust them, to put them back on track, to remind them of their obligation to comply with the terms and conditions of their probation, and to enter an intermediate sentence, maybe just a few days in jail, to remind them, or maybe a return to a program that they haven't been involved in monitoring and making sure that they've done that. But it's a way that those individuals then remain in the community, they remain with their families, they keep their jobs, and we don't interfere with their lives to the point that they go to prison. And hopefully we then prevent future violations that would lead them going to prison. We have 2 levels of this program in Black Hawk County. We have our fast track program, which is designed to intercede very early on. We have another program that we're just starting called Swift, Certain, and Fair, which is meant to deal with more high-level offenders, but the concept is the same. Get in early, be a positive influence, make the sanction only intermediate, and work to prevent future violations. Thank you.
Ms. Sinclair? We have about a minute left here, a little over a minute, so I'm gonna, you're the only candidate who sits on Judicial Council. And I don't think we've ever had one in the past that has sat on Judicial Council, but that's the entity that really makes the decisions about closing courthouses and doing those things. The Supreme Court takes your input, hopefully, but I think you sit with all the Chief Justices and all the court administrators and come up with the plans, and then we either accept it or modify it. So is that how it works? I mean, that's how I see it working.
We give advice and input to the Supreme Court. I would submit that it's ultimately a Supreme Court decision with regard to...
Yeah, we'll take the blame for it, but I know that. But we don't just sit in Des Moines, Iowa and decide what we're going to do.
We are the individuals who are out there. I am the individual who's in my 11 counties on a yearly basis. I know what my clerks are doing. I know what their staff is doing. I know what their needs are. I know how we can craft and use EDMS to keep our courthouses open, I believe, rather than to close our clerk's offices or our courthouses, and that's been an issue. You know, EDMS, when it first came along, which is our electronic system, I think a lot of people were concerned that that meant we were gonna close our rural county courthouses because we were gonna do everything centrally and electronically. I've always viewed EDMS as a way to keep our courthouses open because it allows us to put 2 clerk staff in each of our counties. And maybe Howard County, Iowa doesn't have enough work for 2 clerk staff, but electronically, those clerk staff can work on the Blackhawk County docket or work on the Dubuque County docket, but their persons remain in Howard County and they're there and they're accessible to the citizens of Howard County when they wanna walk in that courthouse.
That's one of the
And
ways
needs-
we've kept the
needs staff.
courthouses open.
Absolutely, yep.
Okay, I think we're out of time unless someone has a question they need to ask. Anyway, Judge, we really appreciate you coming here and we wish you the best of luck.
Thank you.
Thank you.